All right. So good evening and thank you for joining us. I'm Darla Pompilio of Your Tasks, Our Time, Senior Move Management and Professional Organizing Service. Our goal for tonight's presentation is to address many of the misconceptions people have about trusts. Our organization is Senior Services Network of Southeastern PA. We started Senior Services Network because most people are not sure where to begin when navigating resources and often don't know what resources are needed until something happens. We are a group of professionals focused on providing services to seniors. Our goal is to be one place where seniors, caregivers, and families can have access to service providers in the southeastern Pennsylvania area. So tonight, I'd like to introduce our first speaker, and that's Jessica Sauer, Esquire of the Sauer Law Firm. Jessica is a lawyer who loves helping clients create estate planning documents customized to meet their wishes and needs. Jessica has been practicing law for over 13 years and has experience with litigation, estate planning, estate administration, and guardianship actions. She's also the co-chair of the Chancery and Probate Committee of the Mercer County Bar Association. In addition to creating wills, trusts, and powers of attorney, she has also assisted families with creating special needs trusts, a tool that can be helpful when planning for a loved one who is suffering from Alzheimer's or other difficult medical conditions. In addition to designing estate plans to appropriately address personal challenges, she is also passionate about ensuring that families consider and incorporate tax and charitable planning as appropriate. Licensed in both New Jersey and Pennsylvania, Jessica is willing and able to meet the legal needs of individuals and families in the greater Philadelphia area and Bucks County, Pennsylvania. So before our speakers begin, I want to invite those who have questions for the panelists to please add those questions to the chat. After both speakers have completed their presentations, we will go to your questions. So Jessica, I give you the floor.
Thank you so much, Darla. I appreciate it. I'm going to go ahead and pull up my presentation. All right, so we're here tonight to talk about trusts, and specifically trusts in the context of estate planning. And I'll be covering, some of the different trust types that are out there, and then Rich will follow up talking about some of the other trusts that exist as well. So there are many misconceptions about trust, and some people have the perception that trusts are only for the rich and famous. The image of Richie Rich or other famous characters in books and movies might come to mind as trusts only being available for people who are extremely wealthy. And the reality is that's not the case, and there can be many reasons why you might want to create a trust without having to be a quote-unquote trust fund baby. The second misconception is that trusts can be really complicated. And while they certainly can be, and there are certain language and clauses that should be in there to do proper tax planning, depending on your situation, really the trust needs to be as complicated as you wish to make it. So there certainly are situations where you can keep your trust relatively simple and straightforward. The final misconception is that trusts are very expensive. And while trusts certainly do cost more than creating a simple will, the expense of your trust depends on the attorney you work with, and again, how complex the trust is designed to be. So what is a trust? A trust is essentially an agreement that you create for the management and distribution of your property. And you do that by being the creator or grantor of the trust, and then also having someone there to administer the trust. And who that person is can vary widely depending on the type of trust created. And, a trust typically does not stand on its own as your estate plan. It's typically made in conjunction with other important documents, such as a healthcare power of attorney, which would typically also include a living will for making end-of-life decisions, a financial power of attorney that allows someone to make decisions regarding your legal affairs, which can't be assigned through a trust, and then business decisions that remain outside of the trust itself, and a will. And even if you're creating a revocable living trust, it's important to have a will in case certain assets don't fit into your trust, or in case, for example, your estate is entitled to a judgment and someone needs to go and sue someone else after you pass away. Oops. So There are a number of different trust types, and I find it helpful to explain what they are because sometimes when people think about trust, it's easy to interchange them and not really understand which are which. So first, the simplest type of trust is typically a testamentary trust or a trust created under someone's will. I like to call these trusts just add water trusts because while you're creating them, for example, maybe a very simple trust for children under a typical will, you're not going to actually need to fund that trust until after the person passes away. So really the will stands on its own until the trusts inside of it are needed. The second type of trust, which is probably the most commonly used trust in estate planning other than the testamentary trust, is essentially a tool to organize your assets so that while you're alive, you retain the ability to change the trust so that you can change how assets are distributed. You can even get rid of the trust if you end up not liking it after you start to use it. I like to call these trusts informally Ziploc Bag Trusts because of your ability to open them up and take things in and out with ease. Also, just like a Ziploc bag, these trusts tend to be transparent for tax purposes so that you're reporting income from these trusts on your own return. Another type of trust is an irrevocable trust, and this type of trust is almost like a ballot box in the sense that once you figure out what you want to do with it, you're typically putting that aside and only letting someone else open that box back up to change the rules. So examples of this include the Medicaid Asset Protections Trust that Rich will be speaking about later this evening, and then other types of trusts where the goal is really to take the power out of your hands to modify the trust. And the reason typically why you would want to do that would be a tax incentive to do so. And it's worth noting that after you pass away, even that Ziploc bag type revocable living trust becomes irrevocable. So that way the rules that you're establishing are fixed for your beneficiaries. But if that wasn't confusing enough, there are many other kinds of trusts. And so I want to highlight those as well, just so that you understand different trusts that exist. So we first talked about one of them, that age restrictions trust, which is typically in every will to make sure that money that goes to children or grandchildren is kept safe for them until they turn certain ages. Beyond that, you might wish to create a trust for your spouse, which would be known as a marital trust. You could create a family trust where the beneficiaries are both your spouse and your descendants. You might keep money in lifetime trusts for your children or for your spouse, just protecting that against creditors and in the event of divorce. A dynasty trust can keep assets in your family for generations. And then special needs trust planning can also be incorporated within a revocable trust or under a will, and similarly with a retirement stretch trust. For these last two, special needs trusts and retirement stretch trusts, they can also stand on their own as independent trusts, and that's another very common way of utilizing these types of trusts. So when you're thinking about what type of trust to create, you really want to think about the purpose of why you're creating it. Because really, you want to create it with a specific goal in mind so that you're making sure you achieve it. So you look first to the purpose of the trust. So if, for example, your goal is to find basic coverage for minors, whether that be children or grandchildren, then the solution is typically a testamentary trust. Making sure in your will, you're not going to be giving assets to minors and then have to have a guardian appointed to manage those assets for them. If your goal is to make things easier for your loved ones and avoid probate while still being able to take advantage of the step up in basis, then you're likely looking at what's known as a revocable living trust. So again, that Ziploc bag type trust. And I'm going to be speaking more about this type of trust in detail because again, it's the most commonly used trust in estate planning. But the one thing I do want to highlight here is to explain how that step up in basis works. So essentially, if you purchase an asset when it has a very low price, when you go to sell it, you typically need to pay capital gains tax on the difference between what you bought it for and what you're selling it for. If you hold on to an asset until you pass away, then you get what's known as a step up in basis, where essentially you don't need to pay that capital gains tax, or more accurately, the people that are inheriting that asset don't need to pay the tax. There is currently talk in Congress about getting rid of that rule, but for now it's very much in effect, and it can be a key advantage of making sure that assets go where you want to go, but while also retaining the ability to change that in the future. And finally, if your goal is to get assets out of your estate to minimize federal estate taxes or to qualify for government benefits, that's where you want to use those irrevocable trusts of various types, depending on what your goal may be. So another key decision to make is who should serve as the trustee of your trust. For a revocable living trust, it's very common for people to start out serving as their own trustee. And the advantage to that is that if they want to change the trust, they're the only person that needs to be consulted about that. So essentially, they can just execute documents and new versions of the trust very easily. It's also very common for people to have their spouse on as a co-trustee, again, for the same reason. But there may be situations where potentially when you're setting up trusts for your children or grandchildren, you'd rather have someone neutral be the co-trustee or a successor trustee. You can also explore putting family members in and friends. Typically, that's the most cost advantageous way of handling it. But you really, again, want to look at what the purpose is of creating this trust for them and make sure that the trustee that you choose will be aligned with that purpose. So for example, depending on, let's say you want a trust that gives creditor protection, right? In that case, you might not want the person you're seeking creditor protection for to have the ability to make discretionary decisions about how trust assets are distributed. So in that case, you might be inclined to use a neutral person or a corporate trustee. And then finally, should there be a corporate trustee? Well, if you're creating a revocable living trust to be there to support you as you age, having a co-trustee can be a great way to ensure a more seamless transition. And essentially how that works is that while you still have capacity, you would proactively put that person on as a co-trustee so that they're already on all of your assets and accounts, so that when you pass away or become incapacitated, it's much easier for them to step in and handle your affairs. So the identity of the trustee is so important because the trustee is really the gatekeeper for how funds from the trust are spent. So you really want to take time to think through this carefully and put in someone who will honor your wishes and goals. So let's talk in more detail about the revocable living trust. And again, that's that Ziploc bag type trust. And one of the major benefits of this type of trust is its potential for avoiding probate. So in order for that to be effective, you have to have your assets in that trust. But the benefits of this can be really great when you have assets in multiple jurisdictions. So instead of having to file for probate in multiple states, if you have your assets in a trust, it can be one way of bypassing probate. Granted, there are other ways to bypass probate, and those should also be discussed with your attorney. But this is one of the simpler methods for bringing large groups of assets together and getting them out of your probate estate and dealing with them more privately. And there can be different benefits for that, again, you should explore to see if they make sense for you, because in some cases, avoiding probate might not necessarily need to be your top priority. To the extent that you have assets in multiple jurisdictions, it should become a stronger priority. Other benefits of creating a revocable trust include making things easier for your loved ones after you pass away. And the way that that happens is that you can front load the work of funding your trust and taking that step to move assets from your own name to moving them into your trust. If you don't take that route, then after you pass away, essentially your loved ones need to go get appointed as your executor. They then need to move assets into an estate account, and then they need to distribute those assets out again to others. So by taking this step now, you're avoiding steps that would need to be taken later. And as anyone who's dealt with changing beneficiary designations and changing account ownership knows, it can take a while to line up all those details. So for people that want to be proactive and take some of the burden off of others, this can be a nice benefit. Within a revocable living trust, you can definitely set up many different types of trusts. So as we discussed on that second page, you can set up trusts for your spouse and descendants that have really valuable benefits. Part of the reason why you might opt to do that in a revocable living trust as opposed to under the will is the complexity of those trusts. So the longer the trusts are in existence, the higher the likelihood might be that we might need to make some modifications to those trusts in the future to take advantage of available tax benefits, or even to modify the trustee at some point. By creating these in a revocable living trust, we don't need to go to the court for approval for those actions. And anytime we can avoid going into court, that's a win, I think, in the book of the client, because it's bound to save significant expense and aggravation. And finally, as noted earlier, we can make the transition much easier into having a co-trustee and having a more seamless exchange of assets. When assets are in your own name and your goal is to get them to someone else, there are many different rules that apply that can essentially take a while before you're able to transfer those funds to others. So what do you really need to do to take advantage of these benefits of creating a revocable living trust? Well, first, you obviously have to create it, which typically involves talking with your attorney and getting it established. And then the next step, as alluded to earlier, is funding the trust. But what does that actually mean? How do you fund your trust? So basically, typically how this works is when you're creating a revocable living trust, you want it to be the owner of most of the assets that you own, especially the ones, or particularly the ones that should be distributed by the trust. And it's important to talk with your attorney to figure out, okay, are there assets in your estate that should be distributed in another way? Should we combine this with another trust planning tool or a beneficiary designation? And so you want to kind of look at what's going on, who the assets should be going to, and then what's the most tax efficient way to get them there. So for example, sometimes if you're planning to leave money to a sibling, you might want to do that through your life insurance beneficiary designation to avoid inheritance taxes. But generally speaking, if your goal is to have assets disposed of by your trust, you want them to be owned by your trust. The one major exception being your retirement accounts, because those are by definition individual retirement accounts or IRAs. Those need to stay in your own name until after you pass away. And then from there, the trust could be named as a beneficiary of those accounts. So if that sounds confusing, don't worry, you're not alone in figuring that out. It's important to talk to your attorney and figure out how that should work. So to get that change of ownership to take effect, essentially you need to switch assets from being in your own name into having them be owned by the trustee of your trust. So if you are your own trustee, then it would be your name. So in this example, it's my name, Jessica Sauer, as the trustee of the Sauer Living Trust. And you can typically call your revocable living trust whatever you want. Most people will use their last name, but you can certainly, name it something else. Just be advised that that name will be on your checks. So you want it to be something that you'd be proud for the world to know is affiliated with you. For other types of accounts, like real estate and deeds, or real estate, you would change them into the trust using deeds. And for bank accounts and other investments, you would want to use change of ownership forms with your bank. So to help clients move assets into their trust, at my law firm, I create something known as a certificate of trust. And I'm going to show you just a really abbreviated sample here. I haven't included the notary provisions or anything in it. It's blank, but essentially you would put the name of the trust on and key information about the trust, who created it, who's the trustee, what's the tax ID number, and then you would delineate key provisions about the trust. So you would list some of the powers that the trustee has, because a bank is going to want to know who has authority to act. And essentially, you're making it easier to facilitate this process of having the trust named as a beneficiary, because a bank is going to want to know that the trustee really has authority to act before they're going to allow the trust to open an account. So once you actually open those accounts, it's just really critical to make sure that you keep proof of having done that, so that if something happens to the bank or other institution, or more likely if your family isn't sure, right, if you've done that or not, they can look at a clear paper trail to see where those assets are held and what's designated. And before you shut down the accounts in your own name, you want to make sure that you're transferring any auto pays or deposits over to the new trust accounts. So the goal, when you've achieved funding your trust, is essentially to have those assets owned by your trust or named as a beneficiary, unless there's a really good reason to do otherwise. So, just going through those steps. First, you fund the trust. The next step, and you typically do this step when you create your other documents, is to have a pour over will. That essentially says that if you didn't get a chance to fund the trust, because it can take a while to do all the paperwork and get everything lined up, anything remaining will pass into your trust through your estate. Once the trust is created during your lifetime, you're going to pay trust income taxes on your own return. So again, that transparency of the trust for tax purposes, you're going to pay at the same rates you would as an individual, and there can be language in the trust allowing you to take advantage of different kinds of tax incentives the same way you would as an individual. And then you'll expend trust funds as the trust directs. And in most of these trusts, it says that trust money can be spent on whatever the grantor directs it to be spent on. So again, you're either acting as your own trustee or directing the trustee to use the money for whatever you want during your lifetime. It's only after you pass away that the rules become fixed. So, again, you can change the trust if you're not happy with how it's going. And again, it's very important to consider appointing a co-trustee before you actually need help. And a key reason for why you might want to consider doing this is that if you just say in the trust, okay, a successor trustee will step up in the event of my death or incapacity, it's pretty clear on death, right? But if you're incapacitated, it can be harder to prove that. And, it might put your family members in a position of having to take you to multiple doctors and getting those doctors to sign off saying that you're completely incapable of handling your own affairs before someone can help manage trust assets. And to me, that's not an ideal situation. I think a better option is having someone that you really trust serve as your co-trustee so that because you retain the power to get rid of them as a co-trustee if you don't like what they're doing, but it gives you an opportunity to see, okay, how will these people that I think will carry out my wishes actually do it in the real world? And how do you make that transition easier for your family members? So, it really puts the power in your hands to decide when, that co-trustee should step in, but I do recommend doing it before it's definitely needed. It just makes things easier for everyone. And a very common approach for many seniors is that, they'll start out with their spouse as a co-trustee. And then when their spouse passes away, that's the point where typically one of their children would step on with the surviving parent as the co-trustee. But again, you can structure it however you like. And this is just a suggestion. You certainly don't have to do it and can continue as your own trustee until it's absolutely necessary. So the control is up to you. All right. So what happens to this kind of trust after you pass away? Well, we've already learned the trust becomes irrevocable, and then there are some key tasks that the trustee needs to undertake. So while you're alive, you use your social security number as the tax ID for the trust. After you pass away, that's no longer possible. You need to request a new tax ID from the IRS. When that's done, the trustee will begin the process of making sure trust assets are gathered together. Typically, the trust will provide that you can pay for your funeral expenses and estate administration expenses, if any, out of the trust itself. And then once those things are taken care of, trust assets can be distributed to the beneficiaries, or if you've created subtrusts, out to those subtrusts. And until everything is distributed, you're going to want to make sure your trustee files annual income tax returns for the trust. And it may be beneficial to send some of that income out to the beneficiaries so that they're paying taxes at a lower rate. Otherwise, money that's kept in the trust will pay at the highest rate, which is an outcome we typically want to avoid. So we had talked about misconceptions, so now let's talk about some of the realities. And the reality is that revocable trusts are very commonly used to avoid probate and simplify the process for many families of grieving the loss of a parent or loved one. Another reality is that your trust only needs to be as complicated as you wish to make it to be and your situation requires. And a third reality is that revocable living trusts can front load the work and cost of administration, making things easier and more cost effective for your family down the road. Again, that depends on your family situation and your goals, so it's important to think through them as part of your plan. So, is it worth it? That's really ultimately the question you need to ask yourself in creating the trust. So you really want to consider what your goals are, whether you have interest in going through that process of funding your trust, because it can certainly take a lot of time and energy. And then thinking through, well, what are you really trying to achieve and what's the best way to do that? So you should certainly discuss it with your spouse and trusted advisors. A financial advisor can certainly be invaluable to help you weigh the pros and cons, but eventually I strongly recommend you meet with an attorney to see if this is the right solution for you. And, this is what I do with clients and certainly would be happy to meet with you if you have interest. I can be emailed at jessica@sauerfirm.com, or you're welcome to text me anytime at the number below, 201-779-0416. But if you'd like a bit more information about this in general, I've gone ahead and added something to my website today to help you have some more resources at your disposal. So if you were to visit my law firm website, sauerfirm.com, and click on resources, you would click on the section, what is a revocable living trust? And that'll take you to a detailed article I've written highlighting not just the things I've said today, but getting into things in a little more detail. So I definitely would invite you to check that out if you have interest. Thank you so much for for being here today and asking, allowing me to speak with you. I do know that there's a question in the chat about an ABLE account. And I just want to address that briefly. The question is, what is the benefit of a trust over using an ABLE account? I have an ABLE account, but I'm unsure of how it can really help me. What would happen after I pass with the funds in it? So an ABLE account is different from a trust because an ABLE account is more like a bank account that has certain rules about when money can be contributed to it and how it can be used. It's typically not a substitute for a revocable living trust. It's typically used more in a special needs context. And so I think what I will plan to do is will respond to this question more offline in detail. But if you have any other questions you want me to address, please feel free to email me anytime and I'll get back to you when I can. Thank you so much.
Thank you, Jessica. Okay, so our next speaker is Richard L. Newman, Esquire of the Law Office of Richard L. Newman. Richard is the founder of Newman Elder Law with an office in Doylestown, PA. Mr. Newman is licensed in the Commonwealth of Pennsylvania and practices elder law and special needs planning. His practice serves clients in Bucks and Montgomery counties, Philadelphia, and the surrounding suburbs. Mr. Newman has more than 35 years of legal experience and is the chair of the Pennsylvania Bar Elder Law Section. So without further ado, I give you Rich. You're muted.
Me. So Darla, thank you very much. And Jessica, that was an amazing presentation, very informative and explained in a very easy to understand way. I am going to piggyback on some of the information that Jessica talked about. However, as an elder law attorney, I am going to talk about the one kind of trust that I am generally asked to investigate and possibly prepare for my senior clients. And that is something called a Medicaid Asset Protection Trust. And you saw that referenced in part of Jessica's presentation, but I'm going to go into a little bit more detail about that kind of trust. The purpose of this trust is indicated in the second and third words of the trust name. It is designed primarily to protect someone's assets. And typically that would be in the scenario where someone is getting skilled nursing care and they don't want to see all of the assets they've accumulated during the course of their lifetime go and get spent down on their care. So one of the tools that may be in a person's toolbox would be this Medicaid Asset Protection Trust. But as you'll see a little bit later on, this is not something that is available for everyone. So what are the requirements for a Medicaid Asset Protection Trust? And basically there are two. One is that the trust has to be irrevocable. And you heard Jessica talk about revocable trust versus irrevocable trust. Well, this can only be an irrevocable trust. And by that, I mean, once the assets are transferred to the trust, once the trust is funded, the assets can never go back into the ownership or possession of the grantor, the person who made the trust. So in essence, the door swings one way. Once the trust is funded, the door slams shut and the grantor no longer has access to those funds. I do get asked a question, well, why can't we use a revocable living trust like the kind that Jessica talked about a few minutes ago? And the reason that you can't rely on a revocable living trust to protect assets is because a revocable trust is by its very nature revocable, which means that the grantor can, as Jessica indicated, revoke the trust and resume or assume possession of the assets that are in the trust pretty much anytime he or she wants to, assuming he or she is still mentally competent to do that. Because of that, in a Medicaid situation where you are asking the Commonwealth to approve Medicaid benefits for you, because the trust is revocable, the Commonwealth will take the position that you still own that asset, and that even if you transferred the asset to a revocable living trust, say 10 years ago, and now you're in a nursing home, and now you have no more money, and you apply for Medicaid, the caseworker from the county assistance office reviewing your Medicaid application will properly determine that those assets in the trust are still yours, still in your possession, and still have to be spent down before you can qualify for Medicaid. It doesn't matter how long the assets were in that trust. Whereas an irrevocable trust, once you have transferred the assets to that trust, from that moment on, the asset is no longer in your possession because the trust is irrevocable, and you have severed control. And if that was the only asset you had when you apply for Medicaid, that Medicaid application will be approved because the Commonwealth will determine that you do not own that asset. So again, the key is revocability of the trust. Another requirement besides the trust having to be irrevocable is that the funds of the trust can never go back to the grantor. So he or she can never have direct access to those funds. If the grantor, for example, needed $10,000 to pay for an expense, the trustee can never write a $10,000 check to the grantor, because if the trustee was able to do that, the Commonwealth would say that that is an indication that the grantor still possesses and owns the asset, and would therefore make the asset completely available for Medicaid eligibility purposes. Again, the distinction between a Medicaid asset protection trust and a revocable living trust, like the trust that Jess spoke about, is that transfers to a Medicaid asset protection trust are considered to be a complete severance of control of that asset by the grantor, and therefore would make the asset not countable for Medicaid eligibility purposes. What are the advantages and disadvantages of a Medicaid asset protection trust? Well, one huge advantage of the trust is that in the right set of circumstances, it can shelter significant assets that would normally have to be spent down before someone can qualify for Medicaid. And maybe one of the best examples that I can use would be if you own, say, a vacation house down the Jersey Shore. As far as Medicaid is concerned, if that house is not your primary residence, then the house will be considered a countable asset. And if you don't put the asset into a Medicaid asset protection trust, you will have to sell the house and use the proceeds from the sale of the house to pay for your care if you are in a nursing home. However, if you are able to transfer that property to a Medicaid asset protection trust, then you will no longer be considered to be the owner of that property. And if you have no other assets, no other countable assets, then you can qualify for Medicaid. And when you pass away, the proceeds from that Jersey Shore property can be distributed to the beneficiaries named in your trust. Also, as Jessica said, an advantage of putting a Jersey property or a property on the Jersey Shore into a Medicaid asset protection trust, just like with a revocable living trust, is that you no longer have to probate that asset in the state of New Jersey when you pass away, or your executor doesn't have to. Jessica mentioned in her presentation something called a step up in basis, and you also, in most cases, will get a step up in basis when you transfer assets to a Medicaid asset protection trust. It depends on how the trust is structured, but most of the time you will get that step up, which, as Jessica indicated, would mean that there would be less of a capital gains tax exposure after you pass away and the asset is sold by the trustee. So those are some significant advantages of a Medicaid asset protection trust. What are the disadvantages? Well, it's something I mentioned several times already, but you do suffer or you do sustain a loss of control. And for some people, that is a factor in deciding not to use this trust. People have a hard time getting past the fact that they can't control that asset anymore. So for example, if you have an investment account and you decide that you want to transfer that investment account to the Medicaid Asset Protection Trust, you no longer control that account. Any decisions regarding that account would typically have to be made by the trustee that you name for that Medicaid Asset Protection Trust. And there are people who feel very uncomfortable giving up that ability to control the asset. Same thing with transferring a property to a Medicaid Asset Protection Trust. You have a loss of control of the property. The property is now owned by the trust, administered by a trustee. Many people feel very uncomfortable severing control of their house and giving control of that house to their trust. Also, if your property is subject to a mortgage, the mortgage company may object to you transferring the property to a Medicaid Asset Protection Trust. They would prefer that you keep the property in your name so that you're still responsible for making the payments on that mortgage. Another disadvantage of a Medicaid Asset Protection Trust is that in the right set of circumstances, or in most set of circumstances, you no longer have access to the income generated by the assets that are in the trust. Now, technically, I will tell you that income in a Medicaid Asset Protection Trust can go back to the grantor. However, there are two reasons why I prefer not to have that option. The first is that even though technically, like I said, income can go back to the grantor, there are still some caseworkers in various county assistance offices throughout the state that will take the position that because the income is available to the grantor, the entire asset is also available to the grantor. So the caseworker will deny the Medicaid application, which could result in a court battle down the road when you're trying to have that caseworker's decision overturned. Also, if you do go on Medicaid in any set of circumstances, Medicaid rules require that your income goes to pay the nursing home. So your Social Security, your pension income, all of that has to go to the nursing home if you have been approved for medical assistance. Well, if you have income from the trust that is going to you over the course of years since you have transferred that asset to the trust, you can't turn that spigot off when you're in the nursing home and on Medicaid. And that means that the income from the trust will have to go to the nursing home. It can't stay in the trust, increasing the value of that asset. And so for those reasons, I recommend not allowing the income go to the grantor. And that can be problematic. For example, if you own rental property and you rely on the income from that rental property to support yourself every month, then it would be inadvisable, in my opinion, to transfer that asset to the Medicaid Asset Protection Trust, because now you would no longer be able to have access to the income. So that's another disadvantage and another reason why people choose not to use a Medicaid Asset Protection Trust. But I'm saving the biggest disadvantage for last. And that is anytime you transfer an asset to a trust, any trust, but since I'm talking about Medicaid Asset Protection Trust, I'm going to focus on that. Anytime you transfer an asset to the trust, it triggers a 5-year look back period. And we'll take a step back and just tell people, if they're not aware or familiar with this, the 5-year look back period means that you are not allowed to give away or transfer assets for less than fair market value within 5 years of the date that you claim you're eligible for Medicaid. So if you transfer, say, the Jersey Shore house to the trust, and 3 years later, you run out of money and you're in a nursing home and you apply for Medicaid, the caseworker assigned to review your application will see that you have in fact transferred an asset that could be worth a lot of money to this trust within that 5-year look back period. And the caseworker will then assess what's called a period of ineligibility. And that is the number of days that the state will not pay Medicaid benefits because of the asset transfer. The period of ineligibility starts when you would have otherwise qualified for Medicaid, which means it starts when you're broke. So if you transfer the Jersey property to the trust, you are potentially creating a period of ineligibility for a number of years, 3, 4, 5 years. And because this trust is irrevocable, you can't say, oh, I made a mistake. I want the asset out of the trust and back in my name. You can't do that. And because you have this multi-year period of ineligibility, in Pennsylvania, we have something called the Filial Responsibility Law, which says that children of indigent parents are responsible for their parents' bill. And that means that a nursing home can go after your children because of this transfer to the trust. So again, you don't want to willy-nilly just transfer assets to the trust. I like to say that if you are risk adverse, which most people are, that you should have at least 5 years worth of assets that you keep out of the trust, and anything over and above that, you can then consider transferring to a Medicaid Asset Protection Trust. Let me give you an example to show you what I mean. Let's say that your monthly income is $2,500. So the calculations that I would do based on that is that I would take a look at what the monthly cost of a nursing home is, and I generally estimate that cost to be $15,000 a month, which is not unusual in this day and age. So I would subtract $2,500 from the $15,000 monthly nursing home cost, leaving a monthly shortage of $12,500. That is the amount each month that you will have to pay privately to make up the difference to pay that nursing home's monthly bill. I will then take the $12,500 and multiply it by 60. 60 represents the number of months making up the 5 years. $12,500 times 60 is $750,000. So in that scenario, if you are risk adverse, then you want to have at least $750,000 to keep out of the trust to pay for 5 years worth of nursing home payments before you take any assets over that amount and transfer it to the trust. Now, if you happen to have, say, a higher income than $2,500, maybe $4,000, $5,000 a month income, or if you have long-term care insurance, then the amount you need to keep out of the trust would be lower. So for example, let's say you have somebody that has a standalone traditional long-term care insurance policy, and because they bought it years ago, it's one of the policies that has a $130 day payout period, and the payout period lasts for the full 5 years. So in that scenario, I go back to the $15,000 a month nursing home charge. I subtract the $2,500 income, and I also subtract $3,954.17, which would be the monthly amount that the long-term care insurance carrier will pay the nursing home. And now I have a monthly shortage of $8,545.83. And that's significantly less than the $12,500 that we were talking about before in the first hypothetical. Now I multiply that $8,545.83 by the 60 months. We come up with $5,000 and $512,748.80. So that's 512,749.80. And that would represent the amount that you could keep out of the trust. Again, it's significantly less than the $7,500 that the first person would have to keep out. But either way, $7,500, $512,000, that's a lot of money, which is why this trust is not available for a lot of people. But in the right set of circumstances, if you are able to take advantage of this Medicaid Asset Protection Trust, you not only shelter the assets from a nursing home while you're alive, but you also shelter it from the Commonwealth once you pass away. What do I mean by that? Pennsylvania and every other state in the country has something called Medicaid estate recovery. That gives the Commonwealth the right to make a claim against the Medicaid beneficiary for the amount of money that the Commonwealth paid on that person's behalf. In Pennsylvania, we have something called limited estate recovery. And that means that the Commonwealth's claim only pertains to probate assets, assets that pass through your will. In New Jersey, by the way, they have expanded estate recovery, which means all assets are subject to the state's claim. But because we have limited estate recovery, the asset that is in the Medicaid Asset Protection Trust is considered to be a non-probate asset, not subject to the Commonwealth's claim. So again, if you are able to utilize this trust, you protect the assets while you're alive and after you pass away. So it can be, in the right set of circumstances, a very effective asset protection planning tool. I saw there was a question, but I didn't have a chance to read the question. I'm just going to pop up the chat box.
Yeah.
How often does Pennsylvania actually enforce filial responsibility? Isn't it very rare? Oh, that's from Jess. Okay. Well, Pennsylvania actually never enforces the filial responsibility law. It is a nursing home that could enforce it. The nursing home has the right to make a claim against the children of the indigent parent. And I would say that nursing homes are use that as often as they can. There was a case that was decided, I'm going to say 7, 8 years ago. It's the HRH versus Pittas case, Pittas. And that was a case that was decided by the Pennsylvania Supreme Court that said that the nursing home could go after the son for their $93,000 unpaid bill. So filial responsibility is out there. It's not a theory in law. Nursing homes can use it, and they will if the circumstances warrant it. And circumstances, by that I mean somebody is no longer eligible for Medicaid because they did improper gifting, including to a trust. Let's see. What is the benefit of a trust over? Oh, that was Jess's question. I don't think there are any other questions. With that, then I would like to thank everybody, as Jess did, for being here tonight. I enjoyed providing you with this information. And if you do have any questions, you can certainly get in touch with me. My information is on the Senior Services Network's website, and I would be very, very happy to talk to you about any questions you have regarding this or any other questions you have regarding protecting assets. So again, thank you very much, and be safe and be well, everyone.
Thank you, Jessica and Rich, for all the informative presentation. It was great. Thank you very much. Before we close, I would like to highlight our upcoming presentations. The next webinar is on June 15th, and that is Maximizing Your Social Security Benefits with Beth Frizzell Jenkins. Then on July 20th, we have Setting Up a Safe Home as You Age, and that's with Elaine Ciafani and myself, Darla Pompilio. We do have a very short 3-question survey that we would very much appreciate you completing. This survey will help us plan for future topics and keep us on track for creating content that you want and need. Finally, we are happy to answer any questions about what we do, and we invite you to check out our website. If you have any questions about this evening's presentation, please feel free to reach out directly to our speakers. Until next time, we look forward to hearing from you and hope you, your family, and loved ones will join us each month. Thank you.